Hello everyone and welcome to Tatev Talks Law. This series is being produced in collaboration with the International Law Society at Penn State Dickinson Law to build a bridge between US and European, including Armenian legal communities, by sharing practical insights into how different legal systems operate. My name is Tatev. I am a Fulbright scholar and a law student at Penn State Dickinson Law, and through this podcast I wanted to create a space to explore law from a comparative perspective and learn directly from legal professionals. I am also joined today by Brendan Lay, the president of the International Law Society at Penn State Dickinson Law, who will be co-hosting this episode with me. In today's episode, we will be focusing on intellectual property, competition law, and the broader challenges shaping innovation and regulation in a global context. I am really pleased to be joined by Professor Daryl Lim, Associate Dean for Research and Strategic Partnerships and Founding Director of the Intellectual Property Law and Innovation Initiative. Professor Lim is an internationally recognized expert in intellectual property and antitrust law, whose work explores how law interacts with technologies and policy. And on a personal note, I had the opportunity to take antitrust law with Professor Lim, and I was really impressed by his teaching style and the way he connects complex legal concepts with real-world developments, which makes the conversation especially exciting for me. You work extensively in both intellectual property and competition law. How would you describe the key issues currently shaping each of these fields?
Well, first of all, Tatev, thank you for inviting me to be part of this magnificent series. And I see that you have got Brandon, and it's really important that you're having both the perspectives that you have, but also the perspectives that Brandon is bringing. So I'm looking forward to this conversation. You're asking about the synergy between the two. Well, I'd say intellectual property and competition law, we call it antitrust law in the US, has been very much challenged by the rise of data, and how data doesn't just affect a clean line, for example, in patent law between the invention and the end product, but really you're talking about systems. And similarly with antitrust law, you're no longer just talking about one or several undertakings coming together, but you're really talking about entire ecosystems, and the role of data is central to both of these areas of the law, as both of you know.
Thank you so much, Professor. And continuing this topic, from a practical perspective, how do intellectual property rights shape innovation and business strategies, especially in technology-driven industries?
So a big misconception about intellectual property rights is it's really only about the right to exclude. But intellectual property is really a signaling tool. It's a way for people to do business, to license technologies, to think about how intangible assets can be monetized, can be insured, just like many other tangible assets that we have. And with most of the S&P value now being intangible, it's a critically important area for anybody who's doing any type of business in the world today to understand, if not be able to transact in the language of intellectual property and technology.
Now, in terms of innovation versus regulation, do you think that the current IP frameworks strike the right balance between encouraging innovation and preventing monopolization, or is there any reform that's needed?
Well, it's always iteration, and so every time the new technology comes along, you ask yourself that same question, important question of balance. And you'll never have two people agreeing exactly on whether the right balance is been struck. And that's not a bad thing, because that dialogue is important. You need to be able to consider both sides. Access to medicine is one key area that has been polarizing many communities. Are we giving enough respect to the right to public health? On the other hand, are we balancing the right to get a reward for the innovation and the risks and the investments that you put into that technology? And when you talk about the modern technology with platforms and with AI, we're moving towards a winner-takes-all system. And when that happens, the stakes are even larger, but the marketplace is such that you can only have very few players because the cost of doing business in each of these industries is very high. And both in the innovation space and in the antitrust space, it creates higher stakes, more important risks, but also more complex questions, because these are not just national questions now, and that underscores the value of this conversation that we're having, but international questions, because these challenges respect no borders. And therefore, what it means is you need to have not necessarily uniform rules, because different countries will have different approaches to the same problem, but alignment on those rules, at least some kind of a basic norm, so that somebody doing business in China, somebody doing business in the US, somebody doing business in Europe can have common norms to go by, like we do with our traffic norms or our flight norms or our e-commerce norms. These are increasingly important.
I think it's also important in terms of providing some security to investors. However, we would come back to this point again in terms of international regulations. But right now, we would like to expand on this debatable and arguable topic. And I would like to ask you about the scrutiny of large tech companies, because in recent years, we have seen increased scrutiny of large tech companies. And how is antitrust law evolving to address challenges like market dominance, data control, and algorithmic pricing?
Well, let's talk about algorithmic pricing first. It used to be that it was quite clear that you're looking for some kind of agreement between parties, some kind of an intent to collude. And if you saw that, you would have a case under Section 1 of the Sherman Act. But these days, with algorithmic pricing, it becomes an open question whether or not there was an intent to collude, whether or not there was an agreement between the different parties that are using the algorithm to essentially reach the same result. Well, we heard a former commissioner of the FTC call this the Bob problem, right? If Bob can't do it, go to different people and ask for what prices they're charging and then tell the other people, then the algorithm can't do it. But there's no law that says that that's the case. So the question is, do courts want to expand the scope of antitrust law to catch what is currently completely legal? You solve this problem, but you may create other problems because other forms of legitimate commerce may be swept into this illegality, and that could cause a chilling effect. In the US, we are quite slow to do that because the US is ultimately market driven. Europe is more willing to solve these problems upfront with legislation. And China, for example, takes a different approach. It takes an industrial policy approach. And so all of them are dealing with the same problems, whether you're talking about pricing algorithms or whether you're talking about platforms, but they're coming up with different solutions. And the problem of platforms becomes more central when you talk about democracy, you talk about free access to information, and also becomes more complex because when you access many of these platforms, they don't charge you anything for using it. Think about Facebook, you think about Google, and yet these are important competition issues because it also deals with access, it also deals with innovation, much in the same way that it does with brick and mortar companies. But then again, we're still struggling to see how the law can adapt, and different countries have different responses based on their history, their culture, their geography to that. And I've given you examples of Europe and China. And the differences can vary even year by year. So one thing that China has learned from the US is national security. It's a very useful way of approaching denying a merger. I'll talk about this later on, but the preview here is if you deal with mergers in a typical antitrust way, you know you've got to do your market structure analysis, concentration, market shares, that sort of thing. A lot of trouble. But if you slap on the national security label, you have a shortcut. Everything becomes, oh, it's a matter of national security, so you can't do it. Forget about competition law, forget about antitrust law. You reach the same result. Much more convenient, much less to have to justify. And that's indeed what China did just this week with an entity that is arguably not even Chinese. It decamped, went to Singapore, It now wants to be acquired by Meta, and the Chinese government says you can't do that because the Chinese government is worried if they allow this kind of thing to happen, then other Chinese companies will just set up shop outside of China to be acquired by a US company.
Now, with the rapid development of artificial intelligence, how do you see IP law adapting to questions around ownership, authorship, and protection of AI-generated content?
Yeah, that's an important question. So before AI, there was more or less a clear line from the creation to the invention to the monetization. So you knew who your author was, you knew who your inventor was, you know what your invention or your work of authorship. With AI, it becomes more complicated because who is the author? In the US and indeed many parts of the world, the answer is there has to be a human being identifiable as the author, right? But it's increasingly fraught position as more and more of what we do involves AI, and in each end product there's less and less of what purely
Human
could be said
interaction,
was done by a human. So are you going to exclude all these economically valuable inventions or works of authorship just because there's some tinge of infection by AI? And are you going to expect every author and every inventor to declare and separate what was done by AI, and you catalog everything that was done by you? By the time you do that, the rest of the world would have moved on. And so there's a real challenge in being able to say we are true to our values, but at the same time we want to compete and be ahead of the rest of the world. And I think most countries will take a pragmatic solution because nobody wants to be left behind.
That was one of the most important questions that we wanted to ask you. Do you think that existing IP frameworks are enough and sufficient to address all these challenges which arise with the rapid development of technology and especially AI?
Well, I'm optimistic. This is not our first shake-up. We have had many technologies that have come before. In our recent lifetimes, the internet, peer-to-peer file sharing, these are things that we thought, oh, is that going to overturn IP law? And IP law has adapted. I think IP law will adapt. And indeed, I think many areas of the law, including antitrust law, will adapt. And that is one strength, I would say, of common law systems like the United States, because we work on a case-by-case basis. We can expand it. And if we like it, we make it broader. If we don't like it, we say the facts of the new case are different from the old. And therefore, the conclusion and the reasoning applies only to the old case. In civil law countries, it's more difficult because you could do this as a matter of civil code, and you don't have binding cases. So what exactly should each country do? Even a member states that are so sophisticated as those in the EU, you have the EU AI Act, and then you've got the backtracking of the execution and implementation of the EU AI Act. And it sends a wrong signal, I think, to investors, to startups, that you don't actually know what you're doing. Should I put billions of dollars there and tomorrow the rules change? Or I've already put in millions of dollars from compliance and you're telling me, well, we're going to think about this a little bit more. So there are other places that are more friendly. What they want are clear rules. It can be very rigorous rules. It can be very lax rules, but then it should be clear, and ideally it should be fair. Very few countries can do this well, but it's not a legal problem. It's a political problem. Can the government of the day earn the trust of the stakeholders who are both for and against the change, and bring them together and say, this is the compromise. We'll work with you. We'll make sure that nobody gets left behind, but we need to move forward. In very few countries.
As you mentioned, there has been increasing debate about whether AI can be an author or whether AI can have some IP rights. For example, in cases like Thaler versus Perlmutter, US courts rejected copyright protection for works generated solely by AI. But if I got your position correctly, you think that the use of AI shouldn't affect IP rights of the holder, and we shouldn't have problems in this sense. Please expand on
Sure.
this
So
matter.
the case that you mentioned, Taylor versus Perlmutter, was a reflection of a long-standing position that you need to have a human as the main protagonist in the creation of the work. And they have somewhat softened their position since then by saying, well, okay, if you tell us what part you have created and what parts AI have created, you can still claim for the parts that you have created. But the process, the evidence that you need to show can be very onerous. You need to create logs of what you've done. And if you have ever used ChatGPT or Claude, you know it's more of a conversation. It's not like you put in a sentence and you have the magic answer, and that's all that you submit. And therefore, there's a cost of doing business, right? If I want to protect my rights in the US, I need to do all that. I'm going to look and see, are there more friendly jurisdictions? So I think while this is the correct legal position to take today as a matter of past precedent, it's not a pragmatic solution to take tomorrow if we are going to encourage further creativity and innovation and investment in this field.
No.
And I'll just say one more thing. Business needs drive the law. So if you have any doubt, especially in the US, if you have any doubt that this is not going to be the last word on the law, just look at the whole history of how the law has developed, created legal fictions, so that we can be pro-business, so that ultimately, and this country very much believes so, the technology as it improves will bring everybody else up. And whenever there's a clash between the technologists and the creators, the technologists have always won. And the creators have always adapted. It's not that they've lost and they're worse off. They've adapted. And so, for example, with peer-to-peer file sharing, right? You now have Spotify, which is a direct result of the early file sharing copyright cases. So they've now used that type of technology and monetized it and benefited from it.
I want to talk about your international experience. You talk about there's a need to have a consistent set of rules across many jurisdictions. You have studied at the National University of Singapore. You worked in London, UK. You worked in Bavaria, Germany. You worked in the States. You worked at the University of Illinois at Chicago, and now you're here at Penn State Dickinson. Can you tell us very briefly about the kind of work you did at all of these different institutions?
Well, you're asking me to summarize about 20 years of my life.
Sure.
Briefly.
Yeah, briefly.
I'll give you the brief takeaway, and that is I've realized that wherever you are in the world, you face similar problems. And it's very important to understand that just because other people are approaching the problems differently from you, it doesn't mean that they're worse, they are more unsophisticated. In fact, that there's much that we can learn from each other, which is why I'm a great believer in international dialogues, international conferences. That's where a lot of laws and policies that we read about actually start. And it's a good test bed for whether or not something like that will fly. It's a low stakes, low risks forum to be able to get feedback from very sophisticated people, judges, academics, in-house counsel, outside counsel, civil society, and even law students. And you were there at the forum conference and you saw the type of dialogue that happens. So my time in many of these places has been to appreciate the diversity of perspectives, but also to be able to bring together different people to really think about and help to solve the problems of our times, which are common to all of us.
No. Can you talk about the key differences you observe and how different legal systems approach intellectual property and competition law and antitrust?
Well, I've talked about the differences between the EU, China, and the US. I think you see an increasing blend of political interests overlying these traditional national diversities. And I don't think it's healthy that, for example, everybody is saying this is national security. The reason why they're saying this is national security is in fact them saying we don't trust you. And it's a reflection of a breakdown in trust internationally. And I hope that it will reverse, but that will take, I think, many years. It will take a rebuilding of international institutions. It will take a rebuilding of a global trade system, which has been weaponized with tariffs, with unilateral actions by even medium powers, as we see in the Straits of Hormuz. And that trickles down. You might think, oh, what has this got to do with competition law? Or what has this got to do with IP law? Well, it's people that are making these decisions, and the people who are making these decisions have to take their reading from somewhere, whether it's the political leaders at the top or whether it's the people at the bottom. And this is all going to affect how both sets of laws, or any set of laws, are going to evolve in the years to come.
I would like to a bit rephrase Brendan's question, asking you about whether you see a trend toward global convergence in IP and antitrust regulation, or are jurisdictions becoming more fragmented in your opinion?
So I would say that you are seeing a greater appreciation of commonality of the issues because these are cross-border. It's going to be largely driven by like-minded partners. And so, for example, it's much easier for the US traditionally, I would say, I'm not quite so sure today, to do business in Europe, and they have a common approach. Maybe a more different approach between the US and China. But ironically, if you look at how copyright and AI law has developed, you see much more convergence between US and China than US and Europe. So I can't say that there's one trend that fits everything. You've got to look at it case by case. That's why when law professors give the answer, it depends, they're not necessarily being glib. It's just that it's a complex answer, not a one-size-fits-all answer.
I also think that's the most favorite answer of all the lawyers. It depends, so
yes,
it's completely fine.
Now, given your work in international initiatives, I've heard from the conference that the EU faces a lot of the same problems we face. So things like anti-suit injunctions between two different countries.
Yes.
Within the EU, things like standard essential patents.
Yes.
We face all of those problems here. How important is the international cooperation in shaping the future of IP and antitrust regulation?
Critically important, because again, what anti-suit and anti-suit injunctions are saying is we don't trust you, right? And in this sense, it's also about saying that IP rights should stop at national borders. We shouldn't have another court trying to determine what our court decides what the right rate should be. I think ultimately it's not a problem that litigation can solve, precisely because of the problem that you had identified. There's going to be an escalation of anti-suit injunctions and anti-suit injunctions. This is something that has to be solved, first of all, between the parties through alternative means of dispute resolution, arbitration or mediation or negotiation. And then secondly, as norms get developed, as trust gets developed, a type of code of conduct internationally that could be driven by the World IP Organization or could be driven by multilateral or bilateral trade instruments, so that there is enough of a consensus as to what should happen when people have different views about their own rights, which is not the first time that we have done this. Many years ago, there was a convention on the law of the seas, UNCLOS, that talked about things like right to free passage for merchant ships, which is now being violated by Iran in the Strait of Hormuz. And it didn't start from nothing. It started from conversations and conferences and agreements, and then gradually it became an international law. But you can also see from that just because you have arrived at that consensus doesn't mean that the consensus is good forever. You need to constantly review it, defend it, persuade others to upkeep, and that's the difficult part that often falls on lawyers to do.
I also think that the countries who provide more flexible regulations are more attractive for businesses, and especially in terms of using alternative dispute resolution mechanisms. but I think that's another topic, and we need another episode for that topic. So I would like to touch upon the conference that I recently had the opportunity to attend in New York, Intellectual Property Law and Policy Conference, and I found it truly impressive, both in terms of organizational matters and in bringing together such a large and diverse group of professionals. Thank you so much for your efforts in organizing this amazing conference. How do you see the role of these kinds of events in advancing discussions in intellectual property and influencing real-world legal developments?
Well, thank you for that question. So first of all, the conference, for the benefit of your listeners, is that Hansen IP Institute conference that's held at Fordham University School of Law. And we were fortunate, Penn State Dickinson Law, in the last couple of years to be co-organizers of this conference. And this conference brings together judges, academics, government leaders, civil society, law students from all over the country, from all over the world. It's been called the Davos of the IP world because policies and laws that eventually we read about gets discussed, debated there first. And I thought that was important for law students from Penn State Dickinson Law to be given the opportunity, not just to be attending, sitting there in the audience passively listening, even though that's valuable, but really to participate in the success of the event, to be able to interact with the speakers and get to know them, and more importantly for them to get to know you. And so whether it's in registration or whether it's in timekeeping or ushering, you had the chance to do that. And some of the students also had the chance to contribute article that was published by IPCAP.
Which is amazing, yes.
And their name gets up there on the internet and their article gets read by probably thousands of people. And I think the point I'm hoping to make with students like you who volunteer is that you are never too junior to be a member of this community. You have ideas to offer. You have, in fact, a longer road ahead than most of us. So this is your world that you'll be inheriting, and it's important that you feel like you are playing a useful role and that your views are being valued in this conversation.
After this episode, more and more students would be inspired to participate in the conference.
That conference, we've heard from judges who are from the Unified Patent Court from the EU. We've heard from people from the Singapore International Arbitration Centers. All of these people have special skill set. Whether technical or not, they've been judging, they've been adjudicating patent cases all over the world. So what kind of skills do you think are essential for lawyers who want to work at the intersection of technology, intellectual property, and competition law, and to work in these places like the arbitration centers?
Well, first of all, you need to have a huge appetite for change. No 2 days are ever alike, no 2 years are ever alike. And you've got to constantly refresh your skill set. And of course, these days, one of the most critical skill sets is AI. So you don't have to actually know how to code. That's a bonus, but most people don't and won't have the bandwidth. And in fact, with AI, you wouldn't even need to learn how to code because AI can code for you. But you need to understand the technology enough to understand the legal constraints, the policy constraints, and the different interests that different groups affected by that technology or advancing that technology have. And you need to have a big appetite also for working across borders, because each of these areas that you mentioned affect people not just in your immediate neighborhood, which is it's a very different way of looking at the world from criminal law or family law, which tends to be more local, and that has its important place too. But the areas that you mentioned by nature are international. And that means to say that you need to understand what's going on, not just by reading about it, but actually by talking to people who are living in that. So tomorrow I'm going to be in London, the next week I'm going to be in Rio de Janeiro, the week after that I'm going to be in Spain. And then after that to Seoul, to Singapore, to Sydney, and that's only half the year. So why is it important to travel and to have conferences and meet these people? So that when you say, okay, this is why that person thinks that is important, you know that you've you're not just making up a view or reading about a view from a third-hand account. You're talking to people of actually either advancing the policies on the ground or being affected and advising on those policies on the ground. And then you have more credibility to say, okay, I understand where you're coming from, but there's this other perspective. Maybe the better way to do it is to bring different groups together and see what we can do. And perhaps because people see academics as somewhat benign, people sitting in the ivory tower, so they don't mind when academics say, can you please come for a conference I'm organizing, because they don't think there's an agenda. And usually they're right, there's no agenda. We just want to make the world a better.
Looking ahead, what do you see as the biggest challenges in intellectual property and also in antitrust law, competition law in the next decade? And what skills students shall use to address these challenges?
So I can't look into the crystal ball and tell you what's going to happen in 10 years or even in 1 year. But I can tell you that things are going to continue to change. You should be very familiar, master the fundamentals, because whatever you learned in law school will be the same rule book that everybody in that area will be looking at in confronting the issues. And you need to have that common vocabulary as a junior associate to talk to your partners, to talk to clients about those issues. But beyond that, you have to constantly learn how to learn. For law students who think that their legal education stops at the end of their 3 years or even after they take their bar and pass their bar exam, they'll be sadly mistaken, because whatever they've learned by the time they graduated is probably outdated already. And you are no doubt more current on the law than your senior partners who graduated 30 years ago. And that's a secret weapon, that's a superpower that you have. But you need to constantly keep up with that, because today's partner is tomorrow's you. And there will be other people who will be keeping up with that and who can offer a better bang for the buck.
It's extremely hard to be ahead of all the developments and changes happening in the legal field. So what has been the most challenging part of your professional journey, and what keeps you motivated in such a dynamic field?
Well, what's been most difficult is really keeping up. It's no easier for a law professor to do it, even though it seems easy for a law professor to say it. But what keeps me going is, I think, both the intellectual stimulation I get, but also the practical significance that we can make in this world, especially in these areas that everybody is trying very hard to find answers.
Thank you so much. This was a really insightful and engaging conversation. We enjoyed it, and I truly appreciate you taking time and sharing your expertise and perspective. And thank you to our listeners for joining us on Tatev Talks Law. I hope you enjoyed this episode, and I look forward to seeing you in the next one. Thank you.
Thank you, Professor.
Thank you.